vice chair.
Okay, great.
Good.
Yeah, more just there than here. Yeah, that's fine, that's great. As long as it's out the way.
Yes.
Yeah. Then you said two, they were great. I said that first last year, she was like, oh my God, it's so good, just has so much better. Oh, yeah. Yes, I was, I listened to it twice. I couldn't believe it. Yeah.
Right.
They're selected handpicked. So that means. Well, you let me finish. I was but it makes sense. But it makes so much sense.
Yeah, you don't want to come along. So I don't know how she can.
Oh, dude, and I just thought, I was talking to my friend about this morning, you don't have to wear a mask. Ever since I talked to her about it, she said, and then all of a sudden she's like, oh, that's crazy. That's crazy. And then she reveals that it's shocking. Sometimes the last one. So that's why I'm sure. Oh, that was what? Yeah. That's what we talked about. So that too is that the surface smooth and tight. And it was because you know the last one was shocking. And I'm like, this is really. I was going to say, I listened to it twice on the tour. I love it. Yeah. It is good. So every morning.
Well, we get to, hi, good morning, guys. This is Sheila. You're up because no other lawyer's here. I don't know what's going on.
The difference in this case, last time when we set the stakes, it would be for tonight, the commissioner.
Oh,
So I don't know if he's here.
okay, no worries.
No worries.
All the lawyers talk about it, same time. I have to look, I have to be done by 10:45 because I have an 11 o'clock, 5 trial on it. Such a good. Yes. Yes.
She did say she
Say she.
Right.
years.
Right.
The first one's off.
And Mr. Lewis,
That's how.
they didn't do it out court.
It's, you don't hear about it. So
He's going to be asking for Janice.
It is.
So, we got to try. Yes. Is it across?
Sure.
Yes.
I have a fifth grader, a first grader, and a non-fourth grader. Next month, I'll have to let you know your shadows.
Okay.
Then I share their very teachers. Mr. Greenberg, what's going on there?
Yes, yes.
So we got people.
Mr. Riley, I'm ready for Mr. Markham.
Yes, ma'am. Mark, the forms here, and she can do everything that.
This is a matter of State of Ohio versus Keith Markham, case number B22020095. Mr. Markham is present in the courtroom with his attorney, Mr. Tom Riley, Ms. Kristen Keefner to the State of Ohio. This matter is set today for a plea or trial setting, but it's my understanding the parties have come to an agreement on how to resolve their matter. Is that accurate, Mr. Riley?
That is accurate, ma'am.
Is that your understanding today, Mr. Markham?
Yes, ma'am.
All right. Sir, are you the Keith Markham named in this indictment?
Yes, ma'am.
How old are you?
30,
How far did you go to school, Mr. Markham?
9th grade.
Are you able to read and write the English language well?
Yes, ma'am.
All right. Sir, are you a U.S. citizen?
Yes, ma'am.
Have you ever served in the military?
No, ma'am.
All right. Mr. Markham, I have in my hand a single-page document entitled Waiver of Trial by Jury. There are signatures at the bottom. I recognize Mr. Riley's signature here. Is this your signature? Above, sir, where it says defendant?
Yes, ma'am.
This is an acknowledgement by you that you understand that you have a constitutional right to a trial.
Yes, ma'am.
But when you sign this form, you're indicating to the court, I understand that, but I am waiving or giving up my right to a trial. Is that your understanding of what you were doing when you signed this form?
Yes, ma'am.
Did you sign this form after consulting with Mr. Riley about your constitutional right to a trial?
Yes, ma'am.
Do you have any questions about this form?
No, ma'am.
Do you have any questions about your constitutional right to a trial? I also have in my hand a two-page document entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of Guilty Reduction to Misdemeanor.
Yes, ma'am.
On the second page, there are signatures. I recognize the prosecutor's signature here in blue, Mr. Riley's signature above, and above that, is this your signature, sir, where it says signature of defendant?
Yes, ma'am.
All right, thank you very much. I'm sorry, I had something I'm not doing. Madam Prosecutor, would you put on the record the party's expectation regarding this plea?
Judge, the defendant will be pleading to a carrying concealed weapon, which is charged in count 2. It would be the M1 carrying concealed weapon. The state will be dismissing count 1 per claim.
All right, is that accurate, Mr. Riley?
It is, Your Honor.
Is that your understanding, sir?
Yes, ma'am.
All right. Mr. Markham, are you under the influence of any medications, alcohol, or drugs today?
I do survive.
All right. And does that affect in any way in your ability to understand or think clearly?
No, ma'am.
All right. Do you now, or have you ever been diagnosed with any type of mental health difficulties?
No, ma'am.
Are you presently under any type of probation or community control supervision in this or any other state?
No, ma'am.
Has anyone forced, threatened, or coerced you in any manner into entering into this plea of guilty today?
No, ma'am.
Has anyone promised you anything at all if you enter into this plea of guilty today?
No, ma'am.
Are you making this plea of your own free will?
Yes, ma'am.
All right.
Now, it's my understanding that in this 2-count indictment, they're both felonies, that you have reached an agreement with the prosecutor, the state, that count 1 will be dismissed in exchange for your guilty plea on count 2, which is a carrying concealed weapon, which has been reduced to a misdemeanor in the first degree. Is that your understanding? Is that what you talked to Mr. Riley about?
Yes, ma'am.
Did you have an opportunity to read and review this 2-page plea form with Mr. Riley before you signed it?
Yes, ma'am.
Do you understand what it says?
Yes, ma'am.
Do you have any questions about
No, ma'am.
it? Mr. Markham, do you believe you've had enough time to fully consult with your attorney about your case before this hearing today?
Yes, ma'am.
Has your lawyer answered all of your questions to your satisfaction?
Yes, ma'am.
Have you had an opportunity to review the evidence that the state has against you with Mr. Riley?
Yes, ma'am.
Madam Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material, if any, to your knowledge?
Oh, yeah.
You acknowledge what you're saying.
Yes, Your Honor.
Mr. Markham, are you satisfied with your lawyer, Mr. Riley?
Yes, ma'am.
Now, sir, do you understand the charge against you in count 2 that's being reduced to a misdemeanor of the first degree? It's carrying a concealed weapon.
Yes, ma'am.
Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in the reduced charge of the indictment?
Yes, ma'am.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes, ma'am.
Now, this being a misdemeanor of the first degree, do you understand that you are facing a maximum term of incarceration of 180 days or 6 months and up to a $1,000 fine?
Yes, ma'am.
Do you understand that because this is a misdemeanor of the first degree, that community control is a possibility and that I could place you on community control instead of sending you to prison for a term of 5 years?
Yes, ma'am.
Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court?
Yes, ma'am.
And if I place you on community control or probation and you violate the conditions of community control, you'll be brought back before me for a more restrictive sanction, which could include a whole host of things, but the most severe sanction could be the imposition of jail time up to the 180 days that I previously discussed with you. Do you understand?
Yes, ma'am.
Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service instead of paying court costs. Do you understand?
Yes, ma'am.
Do you have any questions so far?
No.
Sir, when you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons?
Yes, ma'am.
Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a right to have witnesses subpoenaed to come to court and testify on your behalf?
Yes, ma'am.
Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
And finally, do you understand that at trial, you cannot be forced to testify against yourself? You understand that? All right. Do you understand each of these rights I explained them?
Yes, ma'am.
Do you have any questions at all about your constitutional rights?
No.
Do you have any questions at all about anything we've discussed so far?
No, ma'am.
Sir, do you understand that if you plead guilty, you are waiving all of these important constitutional rights? You're giving them up. All right. Knowing everything the court has discussed with you, Mr. Markham, do you still wish to enter a guilty plea
Yes,
to
ma'am.
a reduced charge in count 2, carrying a concealed weapon, and misdemeanor of the first degree?
Yes, ma'am.
All right. May I hear a statement of facts?
Yes, Judge, the indictment was in count 2 that Keith Markham on or about the 30th day of April 2022, Hamilton County, State of Ohio, knowingly carried or had concealed on his person or concealed or a handgun other than a dangerous weapon.
All right. Is there anything further from counsel before I accept the plea?
No, Your Honor, nothing on facts.
All right. Mr. Markham, did you hear what the prosecutor said you did?
Yes, ma'am.
Is it true?
Yes, ma'am.
What is your plea to count 2, carrying a concealed weapon as reduced to a misdemeanor in the first degree?
Guilty.
Let the record reflect that Mr. Keith Markham was present in court with his attorney, Mr. Connor Riley, and that Mr. Markham was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Markham understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Keith Markham guilty as to count 2, carrying a concealed weapon, as reduced to a misdemeanor in the first degree in violation of 2923.12 subsection A2 of the Ohio Revised Code. Count 1 of the indictment will be dismissed at the state's request. Is there any reason why sentence should not be entered today, counsel?
No, Your Honor, we would be willing to waive PSI and proceed to sentencing directly.
All right, who would you like to say on behalf of Mr. Markham?
Thank you, Your Honor. Mr. Markham is very grateful for this offer presented by the prosecutor. He has no prior felonies on his record, so keeping a felony off his record was, you understand what opportunity that was to take advantage of. I don't have the exact date count, he spent about, I think, right around 5 days in jail after he was arrested on this charge. What we're asking the court to consider is placing him on a period of community control. He has made every single court date, actually early, every single court date, taking this process extremely seriously. He's stayed in contact with me. I have full confidence that if given an opportunity on community control, he'll comply with all terms.
All right, thank you very much. State?
Judge, he does not have a felony on he is, I think, possession of drugs in this county for 2010 was a misdemeanor. Ultimately, we will request that forfeiture of the firearm to be deferred to court.
All right, thank you. Mr. Markham, is there anything you'd like to say before I pass sentence?
No, ma'am.
Do you agree that the firearm can be forfeited?
Yes, ma'am.
All right. What are you doing now, sir? What do you do to earn a living?
I work for my father and I work on cars at night.
On cars and,
I work for my father, he's there electric from 8 to 4, and after that I work on cars at night.
oh, I see. All right. And so where do you live?
1768 Esmond Street,
Who do you live with?
myself.
Okay. All right. Well, all right. So what I'm going to do is I am going to order you to pay court costs and a forfeiture of the firearm. I'm not going to place you on probation. I don't want to see you back here. All right?
Thank you.
All right, you have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand?
Yes, ma'am.
I wish you well.
Thank you.
Thank you very much.
Oh, I don't know that, I just wanted to.
Ms. Adams, are you ready? You done with your?
I believe that, that he's been ordered down, so Ms. Jones, she said, oh,
Thank you.
she's gonna talk to him right here as opposed to hanging the.
All right, thank you.
Judge, did you want to do Don Diego Bradley? Sure.
All right, this is the matter of State of Ohio versus Don Diego Bradley, case number B22031999. Ms. Jody Ganoke on behalf of Mr. Bradley, Ms. Kristen Keeper on behalf of the State of Ohio. This is a plea or trial setting, and Ms. Ganoke, we have a trial date set on October 17th. Your client is in the Justice Center. The last time his presence was waived due to illness. And do you want him brought down today?
I did not need time to wait a few minutes.
All right. And how do you want to proceed with this matter?
The state has kindly provided me surveillance video late yesterday afternoon, so I was traveling, I haven't had the opportunity to look at it yet. I know they're diligently working on the medical records, and I believe she needs to address the court as applies to medical records to get that to me.
Okay, I didn't hear the last part.
I believe she's going to address the court, the assistant prosecutor is going to address the court regarding what she needs to help me get the medical records.
Oh, okay, thank you. Ms. Keeper.
Judge, the only remaining piece of discovery that is remaining is the medical records. My victim's advocate was reaching out to the victim, but she has been in 2 trials trying to work on that, so I frankly thought it might just be easier to ask the court for an order so that I can subpoena the victim's certified medical records. I filed that motion, probably won't be filed until this morning. I did let the state know, and I prepared a proposed entry.
All right,
For the victim's medicals.
what's your
Position
position?
to that.
All right, thank you. All right, if there's no being opposition, I will sign this entry order and disclosure of the medical records. Let's go ahead and get a date. We may have to address the trial date at some point, because
It is going
the records, but let's go ahead and get a date about 3 weeks or so out, and then we'll address it then, okay?
You want to do a final pretrial conference?
No, because, well. No, because I didn't have that over yet, so get too close. One more, let's do a status.
We can do a status on, October 5th.
That's fine.
All right, we'll do status October 5th at 9 a.m. and time was waived to the trial date of October 17th.
Yes, Your Honor.
All right, thank you very much, Mrs. Miller. Do you have anything else here?
No, Your Honor. Have a good day.
All right, you too, thank you. All right, Mr. Bennett. I think you can call your case. Jay, can you have your client come in?
I didn't remember, did you have something today after? Sorry, did you?
And then just shoot out your case.
We can stop up.
Sure, we'll come over here, because I have to.
Judge, do you want me to, can I take that entry back from you so I can subpoena those records?
Oh, sure.
Yes.
This, let's give me a copy of this, and give you the picture.
It's about the end of the season. I had to set my sear sucker off for the and storage. That's it. It's over 70. That's my Right now,
I sent it to you and then.
You wouldn't be separate.
They are going to ask for, some of them are gonna ask. All of them really want their money. But you know, I mean, I mean, I can only do what I can do. They, some of them, I'm gonna defer to the court, but some of them are they are toxic, some of them are toxic.
He's not trying to sign it, so I can show you the policy. Yes.
I thought you probably would, but.
This is the matter of State of Ohio versus Latoya Mathis. Case number B21054119. Ms. Mathis is present in the courtroom with her attorney, Mr. Bennett. Mr. Robert Vick is supposed to be here on this. Who's supposed to be covering for Mr. Vick? Is it, I think so. Mr. Dark is supposed to be covering. But you may be able to,
I don't think it matters.
I was gonna say to the prosecutor, it may not matter. There's a separate sentencing, but, my understanding is, Mathis didn't, comply with the pre-sentence investigation report. So, looks like I may not be a sentence today. Ms. Keekner, do you mind covering this? Or do you want to wait till Mr.
I
Clay doesn't know anything about this. Just
He's
like.
covering for Mr. Vick.
well, more money, that's all I need.
All right, so, Mr. Bennett,
Judge,
I wanted to get this case resolved today, as it's been pending 317 days. I ordered Ms. Mathis to go straight to the probation department after court on the last court date, which was July 14th. No, it wasn't July 14th, but. In any event, she did not. And they made all attempts to call her, no response. I don't know what Ms. Mathis is thinking. Okay, August 1st. So I continued it a month and a half. All right, Mr. Bennett, what would you like to say?
Since I was perfectly request the court to continue the sentencing and allow my client, Ms. Mathis, to make contact with the probation department so that they can complete the pre-sentence investigation report. Ms. Mathis is very, very well intended. I don't think there's any type of malicious or intentional disregard of the court's order. I do know that day she did go down to the adult victim and disability on 153, and she followed up their act. she's not, something was missing. That's why I wrote that court. I would ask the court.
Well, did she go to the court clinic? Did you go to the court clinic now?
I was a few conversation because I felt that's all I'm supposed to be, was go down here to, so you said, as soon as I leave down here, I go to that place.
Correct.
So he never told me after that to go somewhere else or I would have went. You know what I'm saying? I don't recall that part. I thought that was the only place I was supposed to go.
Well, when you went down there, what did they tell you?
I signed, I did a little 1 through 10 instead of some, some questions.
Yes.
Paper, and gave it back to him.
And then what?
And then I guess I was supposed to, he was supposed to call me back or.
Correct.
But what was the number that they had there? Because I hear from call all the time.
I can attest to that, because she called me all the time. But what she didn't call John was that nobody followed up with her, other than that, I would have told her what she needed.
Well, that's not what the probation department says. They did call you several times. Now, I don't know if you don't answer phone calls that you don't recognize. I don't know. I don't care. But a month and a half has gone by, and I have no court clinic evaluation, and I have no PSI. And all of this is what you're supposed to be doing. So, this is what we're gonna do. Now, I have options here, Ms. Mathis. I can continue this matter till the, what did I say, Ms. Howard?
You said the 28th, but I didn't know she would do a court clinic evaluation.
No?
Very much on the push.
Sure. I can continue this to the 28th of this month. Or the full 30 days. In any event, I could also take you into custody until the reports are complete to make sure they're done, since there's so much confusion. I don't want any confusion. I just want reports complete so that we can resolve your case. Okay? So, Mr. Bennett,
Judge, I started trial on the 28th day, I prefer the third day.
what will give me any confidence that you're going to have everything completed?
I need to just roll down so I know exactly where I'm going. Exactly what.
Well, I'm telling you what you can do, but I'm not gonna hold your hand to do it. That's really what you're
the right to do it once I.
All right,
I'm gonna lay it down for you, Chris.
all right. Ms. Howard, what do you think?
About, so 17th.
October 17th,
Yes, Your Honor.
October 17th, 9 a.m. We'll continue. Now, I'm told by probation, if you go down today, right after court, they'll do your interview. So that should be easy to take care of. But you also have step 2, court clinic evaluation. And what happens is, we fill out a form, and then they contact you. So you're gonna have to answer phone calls that you don't recognize the number. You understand? Ms. Howard, can we confirm her telephone number? What is it, ma'am?
513, 915, 3316.
$33.15?
All right, it's in the system.
All right, so that's the number that probation is gonna call, that's the number that court clerk is gonna call. Ma'am, if you come back to court and nothing's done, or one of the two isn't done, I'm just gonna go forward with the sentencing, you understand? Without that information. That information helps you. You understand? All right. We'll continue to October 17th, 9 a.m. Anything else, Mr. Bennett?
No.
Anything to say? Oh, Mr. Clark, there you are.
Good morning.
Good morning.
I'm sorry.
No, that's okay. We continued Ms. Mathis' case to the 17th, okay?
Is that October 17th?
October 17th.
Thank you very much.
Thank you very much.
Thank you. Have a nice day.
Thank you, you too.
Yeah, we don't support.
All right, Ms. Jones, Ms. Adams, are you ready?
We are.
Judge, everyone, we have some changes to the trial setting, we already have a trial.
Yeah, let's do it real quick, but I need to give Ms. Jones.
Everything's gonna take me down. No, but you're not, we're not really,
All right, this is the matter of State of Ohio versus Aaron Kincaid, case number B220197. Mr. Clyde Bennett for Mr. Kincaid, Ms. Kristen Keekner for the State of Ohio. This matter is a clear trial setting. Mr. Bennett, we have a trial date October 17th. How do you want to proceed? Do you have all the discovery you need?
I've got everything that I need, and all I can do is judge the matter, we talk about it.
Okay.
And I'll let your office know that before, that we're not doing that.
All right, do I need to set a final pre-trial conference?
No.
So just leave it on for the 17th?
Right, and now I'll let you know. All I can do.
All right,
Thank you.
we'll leave it on, thank you.
So we did it for today.
No, the 17th. All right, this is the matter of State of Ohio versus William Pope, case number B1806331. Mr. Pope is present in the courtroom today with his attorney, Ms. Christine Jones, and Ms. Paula Adams for the State of Ohio. This matter is on for a 2-year review, and I have received a report from the Summit Behavioral Health Care. And I can't remember, I think it's Dr. Moore. Okay. And the opinion is that in a reasonable degree of medical certainty, Mr. Pope is mentally ill due to schizophrenic, schizoaffective disorder, depressive type, and subject to hospitalization by court order, with the least restrictive treatment alternative being Summit Behavioral Health Care. However, they do request that the court allow an increase in privilege level for Mr. Pope to privilege level 4, which would allow him supervised movement outside of the facility and to be able to do some things that he needs to do, like go to the bank, buy items to the commissary. So, counsel, have you received a copy of the report?
I have not, would stipulate, and obviously we're in agreement that Mr. Pope be appropriate for level 4.
All right, thank you very much, Ms. Adams.
Yes, Your Honor, I'd also just like to note for the record that the report also indicates he remains incompetent.
Yes.
It's a routine jurisdiction. But with that, the state would stipulate to the report.
Thank you very much, and you agree with that as well, Ms. Jones?
I do.
All right, thank you very much. All right, so the court is assigning an entry finding Mr. Pope remains incompetent and mentally ill, and signing an order of commitment with increase in privilege level.
Thank you, Your Honor.
Anything else, Counselor?
Nothing further, Your
All
Honor.
right, all right, thank you very much, have a great day. Do you want to walk this through?
Yes.
Oh, you know what, the next hearing date will be September 12th, 2024. The next hearing date, September 12th, 2024. And this is how it's doing it. This will be this as the original copy. And I'm going to, since the party stipulated to support this records. The party stipulated to support, I'm going to, admit it under seal as exhibit.
Because there's statutory warrants that are filed in the clerk's office. So, they are, yeah, they get filed. It's from the appeal, the Supreme Court, or the Court of Appeals, and see that, yeah, because they are in the record, if you look on the clerk's office document, they say the court examiner filed your seal, and you have to go and get a court order to see it served. We never admit them perfect.
Thank you so much for that.
And I saw that it's got moved to a different, I wanted to touch base just to let you know that we're just trying to. It looks like, I mean, it's probably a front briefing.
Oh, yeah, okay.
Right, so,
I wouldn't do it again.
right, but I just wanted to let you know that we're gonna attempt that, so.
Thank you.
Okay.
Appreciate it. This is the matter of State of Ohio versus Jaleel Jones, case number B 2100706B. Mr. Jones is present in the courtroom with his attorney, Mr. Lewis. Good morning.
Good morning, Your Honor.
And Ms. Kristen Keeper for the State of Ohio. This matter is set today for sentencing on probation violation. Are we ready to proceed?
Your Honor, may it please the court, again, I apologize for my tardiness. I was stuck on the Hill in 2020 on a plea. This matter is set for sentencing, but at the court's direction, we wanted to wait until the matter that's before Judge Peck, which is set for a jury trial on October 3rd, was resolved. When we set the date, it was anticipated that that might be resolved by today, but it is not. Again, we go to trial October 3rd before Judge Peck.
All right, so you want to continue until after then?
With the court's permission.
All right, any objection? All right, let's go ahead and get a date right after that.
Thank you, Your Honor. In an abundance of caution, Judge, we have the jury trial set for the 3rd. The trial should be for a day. 5th should work. Should be, I believe, the 3rd, 4th with the testimony.
It's a jury trial or bench?
It's a jury.
Okay.
So the 5th should, we can put that date.
All right, October 5th
Thank you, Judge.
at 9.
We
All
waive-
right.
We waive time, Judge.
All right, thank you very much. Have a good day.
Need a signature? Thank you, Judge.
All right, bye-bye. All right, who do you have next?
Judge, we can do, Jared Whitehead.
Sure. This is a matter of State of Ohio versus Gerard Whitehead, case number B 2201965. Mr. Craig Teakin on behalf of Mr. Whitehead, Ms. Kristen Keeper for the State of Ohio. This matter is set for a clear trial setting. Mr. Teakin, we have a trial date October 3rd. Do you have discovery and are we working our way toward trial?
Your Honor, I have, I believe, most discovery. There's a few items that we had requested that the prosecutor indicated to me they had not gotten any response from. prosecuting witness. So with that in mind, we discussed keeping the trial date, see if they're going to show up with this evidence or not. So that's what I would request.
All right, what about body worn camera?
I do have audio.
Oh, you have that, okay. All right, so, we just need a final pretrial, which trial is the third, though. Let me look at that. Do you want a final pretrial, or do you want me to just keep it on trial?
You would like?
I would like a final pretrial because I would like to, I'm gonna subpoena, the checking place as well as the officer in to ask.
Okay, well, let's go ahead and set a final pretrial. We did probably that last week. And that would be, September 22nd. Oh, it's next week.
I'm actually out of town that whole week except for Friday. Can we do the 23rd? Or I could, if it's just a final pretrial, I can send it to a worker and at least update me.
Okay, perfect. September 22nd?
That works.
Thank you.
Thank you.
All right, September 22nd at 9 a.m. And, all right, we'll do check-in then. Thank you.
Thank you.
Mr. Greenberg,
Yes, you're right.
are you ready for Ms. Prater?
I am.
Okay. Yeah. This is the matter of the state of Ohio versus Ashley Prater, case number B1904543. Ms. Prater is present in the courtroom with her attorney, Mr. Matthew Greenberg, Ms. Kristen Kiepner for the state of Ohio. This matter is here on probation violation, sentencing. And, Mr. Greenberg, are you ready to proceed?
Yes, I am.
All right, we'll try to send a half, Ms. Prater.
Mayor, may I approach with a letter from groups we're coming together? Some, treatment settings.
All right, thank you. All right, Ms. Prater, your name is Hicks.
Yes and no. I'm,
Remaining, right?
my maiden name is Prater. Hicks, I got married at 10, changed it on my social security card and not my driver's license.
Okay.
Divorced.
All right. All right, so you go by Hicks now?
My insurance card is.
Oh,
I'm going
okay.
by Prater, but I just have to.
Oh, I see. Okay. All right, thank you very much. I read the letter from Groups Recovery Together program, and it's signed by Mr. James Campbell, substance abuse counselor. And so it looks like Ms. Prater is in this program doing well.
Yes, Your Honor, if I may, I think it may be helpful to provide a timeline to this case. And Ms. Prater and I just reviewed that before coming in here. So as I show from my notes, on March 31st of 2021, this court sentenced her in this case to 2 years of community control, permitted for costs and fines. And then, and as you call it in the probation violation document, she was not released. She was instead extradited to Indiana, where she was incarcerated in Indiana until December 27th of 2021. So pretty much the remainder of last year. So then she was released on December 27th, and then the court can see from the group's report document that on January 11th, she began treatment. So she was pretty quick in getting started with the treatment that she acknowledges that she needs. It wasn't even ordered on the probation in the sentencing, but she knows she needs structure. And she has been in groups together. And now, on March the 1st of this year, Ms. Prater was re-incarcerated on the same Indiana case. So this is the case that started before the entire sentence here. She was re-incarcerated, and then she was released when she posted bond 8 and 9. I had that bond document, if you want to see that, from Franklin County. Actually, do you have that?
Well, what's your point?
Okay, so then she was released, and then May 19th, she reconnected with the group. Went to letter, she's been involved, engaged with groups ever since. The probation indicates that Ms. Prater has had a difficult time since this year, but with the timeline, I was trying to show the board that I think she's done the best she can, given that she had this burden of this case in Indiana that she's had to deal with. And then she has new charges that have been filed in Indiana, and she has a trial date set November. This is a non-conviction. She has set this case for trial, and she's just reaffirming her rights to take the case to trial. At this time, I don't think that the court should take any view on those new cases. That's a wait and see situation. So with that issue set aside, and the fact that Ms. Prater has been engaged in treatment, and also she's just started a job this past week, working full-time in Burger King. She's
Where?
Springdale,
which is where she lives.
On Glenview?
on Chesterdale and Kemper.
Okay, Tri-County area.
There you go.
All right, thank you.
So, and she can get there easily from where she's living in Springdale. And finally, she is officially an Indiana resident, still, her insurance is there, her groups is in Indiana. She's working on changing her residency. And she tells me she believes she's communicating well with the probation officer. She knows she has to work out all these things with the probation officer. So for all these reasons, I ask the court to continue on probation.
All right, thank you. State.
Can I go to the virtual recording?
All right, that's how I need a copy of this.
I made a copy.
You made a copy already?
All right,
I'll keep this, serious. All right, Miss Prater, anything you want to say?
Just I was asked for you to give me another chance. I'm trying to get back on my feet. Just one step at a time, in the right direction.
All right. Well, I'm glad to know that you've been going to groups, participating in the Groups Recover Together program. Looks like you're doing well. You are being held accountable for your participation, and they say you are punctual to your weekly group therapy. And it doesn't, and you're meeting all the requirements. You're doing your weekly drug screenings, and you're meeting all of the requirements, so that's really good. I'm going to restore your community control. Mr. Greenberg is correct. March 31st, 2021, I put you on community control for 2 years. So I'm not gonna add any more time to that. You just finish out your 2 years, which will be March 2023, which is a few more months. I am gonna order that you continue in your therapy, your treatment with Groups Recover Together. It's gonna be a condition of your community control. So if you think you're just gonna walk out of here and say, oh great, she's been giving me more time, I'm gonna stop going to these groups, that's gonna be a violation of your community control. You understand? And if you violate the terms of community control, you open yourself up to being sentenced to prison up to 12 months. Do you understand?
Yes, ma'am.
All right. So I'm going to remit the court costs today because I am impressed and I'm by you, and I'm glad that you are looks like you're really working hard to stay out of trouble, you got a job, you're going to your groups, you're doing well. And so I'm not adding any more time, you just finish out your community control to March 2023. I wish you well.
Thank you.
All right, you're welcome.
Thank you very much.
Thank you.
David Frazier, Judge.
Let me bring it down.
You want to talk
I
about?
don't think we need to, like, wait here for permission.
Okay, David Frazier. He said he doesn't.
I don't think so.
Okay. This is the matter of State of Ohio versus Damon Frazier, case number B 2103820 and B 2203993. Mr. Frazier is being represented by Mr. Brian Goldberg and Ms. Kristen Keeper for the State of Ohio. Now, on the probation violation, is Robert Jones representing or you represent both?
Your Honor, I think Mr. Jones was appointed because I could not be here when it was first set. I did tell Mr. Jones, with the court's permission, I'd be happy to handle that. He was okay with it.
Okay.
I don't know what the court's position is, and I certainly don't mind handling both of them.
All right, and have you, had an opportunity to meet and talk with Mr. Frazier?
I have.
Okay, all right, well, we can, do that, we can, put you on both cases, and, how do you want to proceed? Will you wait in his presence today? Mr. Frazier?
Well, Judge, I guess the probation violation, made me think I maybe would like to address on the probation violation, I don't know if the court would be willing to allow me to do that without me being here.
Yeah, typically I have you file a motion.
Okay, I can file a motion.
Okay, yeah. All right, so for purposes of the day, do you want to write down?
No,
Okay.
okay.
All right, so I know that the last time the probation violation, counsel did not want to address whether or not you want a proper cause hearing or not. Do you, your client want a proper cause hearing?
Then we would be one way in probable cause.
All right. So we'll waive proper cause on the probation violation, continue it. I'll just put not guilty on the probation violation as well, and continue all of this together. The new case is set for DSC today, and we'll do the trial setting date and a trial date. Ms. Howard?
The trial setting date, October 13th.
That's fine.
All right, so for the trial, October 13th at 9 a.m., and we'll put the probation violation on that day too. And then the jury trial date.
December 5th.
December 5th?
Judge, that's fine. I will say I have a trial scheduled the week before that. That could go into the following week.
Okay,
I'm fine to set it then, but
well, let's set it then, because that's the last jury trial date that the jury commissioner gives us for the year, and I don't want to move it to January. So let's go ahead and set it for December 5th. I know you're gonna file a motion to address bond, so if he gets out, then that will give us more time to resolve this matter. But I wanna keep within like 90 days, since
Sure.
he's incarcerated.
I understand, Judge, and that's fine.
All right, so, is time waived?
We'll wait time.
All right. So if you file a motion for bond, to address the bond, would you kindly hand deliver or email a copy to Ms. Howard?
Absolutely.
Because we don't usually get it until, if something's in strange delivery of the mail, we won't get it until the day after the bond hearing. And it's like, oh, here's the motion. So if you can just drop a copy.
I can do that.
All right, anything else, Mr. Goldberg?
Nothing further, Judge.
All right, thank you very much. Have a good day.
Thank you.
All right, Ms. 311, you've been very, very patient.
I'll text him, he hasn't responded.
I'm trying to get, there you go. Getting ready to. Just have two cases, well, just have one case on the criminal law, and Ms. Keeper, I think you're done.
I think I have Mr. Bogan on.
Oh, you do, because I remember, yes, Mr. Bogan. Mr. Bogan is here.
I'll just make it one then with David Trout.
Do you want your client brought down?
Yes.
All right, let's call down Ms. Purvis.
Your bail is on top of it. She already texted me, and I texted her back.
Oh, excellent. Yeah, she's good like that. I have to go. All the sitting judges are scheduled to go to the judicial conference this afternoon in Columbus, so
Yes.
we're all trying to move our cases. I'm not sure if everyone knows or not, but.
Yeah, can you understand?
Thank you.
Thank you. How far out are you still in sentences?
30 days.
30 days.
Sometimes another week if we are getting it to a crunch, but usually 30 days.
Are we good with the 17th?
This, how, are we gonna get the date
They don't work, Judge.
on this client for sentencing? Very good plea.
Are you reporting at PSI?
Correct, and victim impact.
October 17th.
Can you do October 17th for sentencing?
Yeah, that'd be fine. Thank you.
I'm sure you do, because you're and then you want to cover everything. The lights are sound in the afternoon. Because now they have like 3 fish. I used to work in the probation office and I was
Council, I wanted to let you know that the TRC time changed, so you can change this.
Sure.
It's up to 2 years. At least a year ago.
Sorry, I changed that. I was like, is it 3 years?
Yeah, it changed. It changed the end of it. It's up to 2 years now.
Actually, are we writing now?
Wonderful.
Thank you. Mr. Bowden didn't respond back to silence.
He's upstairs in another room.
What's going on there? And so that's the big deal.
I was just like, I used to like when they would say, the judge would get halfway through to be like, no drugs or alcohol, and they're like, stop. You know, just do the time because I can't do that. And they were like, just, you gotta know your limitations, like, so like, I stop right there. No, I get it. Several people be like, I'll just do this part, which, like, I just always, even if it's like, I need to do it, and I'm like, I can't, honestly, get out of jail, I'm looking at your charge. I always used to think that, like, juvenile court, where people pick the virgin, I'm like, just. Yeah, it's that usually. Can't tell you now. No, just go ahead and plead guilty. Get expunged, that's why. Like, they make you go through all those things, you gotta go to the clinic, you gotta go from your doctor saying, you talk to them, you gotta like, no. If I was like, as a parent, as the one who had to drive you over, like, you're just thinking,
Watch a 1 hour video. I mean,
That's gonna come about it. So it's like, if you got caught on drinking for the abuse, you have to get a note from your doctor saying, talk to them, and whether or not they recommend treatment. And if they recommend treatment, then you have to follow through with it. But again, Kristen does this, it's just really plead guilty is cheaper and you get the same result. Because even if you get diverted, it's still on your record, it's nothing getting expunged. The juvenile court, they always done it for you, right? It's so dumb, it's a racket.
You know, the attorney should talk. You know, I feel like especially public.
Well, I feel like parents come in and parents want like the diversion because they think that it like.
Yeah, I think it's the best option.
Well, and then like it's like moments Randy and they don't let you graduate or she get an underage They.
I thought you had one.
I don't anymore. Don't worry, they'll divert it and it's stable, it's obviously. But the attorneys that make like tons of money on all the drunks.
My brother had a car dealership up by Miami, and like all these parents just come in and they're like, you know, leave, you know.
So to something, the amount of money some of these kids have is unbelievable. Like I couldn't even wrap my mind around.
I was just stuck behind the filibustering defendants who being sent before my case was locked. It was called competency.
Wow. Well, I guess I got good news for you.
You have discovered.
I have a little bit of it.
Very good.
This sounds bad. I spit. No.
No, don't worry. You're all in for it.
Okay, Who's talking?
So I'll be very,
I
What do we have, body cameras?
You're such a body cam.
Other,
Probably.
okay,
Yeah, there's some weird statements in there or all that.
any photos?
Maybe.
Check for that.
And then it'll be on body. That's funny, because the basic room is over there. That's why I don't know where she's still, she doesn't back anymore, so her friend still has like she's, I don't know if like her race.
You could just go there yourself and ask for the first.
Thank you.
Like, you know, I was college, probably, I think it's a wonderful time. But somehow go on vacation or something, and my boyfriend missed his virgin date, and they go, we're out, we're going to jail.
Like just overnight, but it was like, I was like, wow. Like now, like, I'm right in jail. But I was like, it was just. That's true.
Well, Miami is the Chicago North Shore transplant.
You're from Ottawa County?
No, Chicago.
Chicago, I was gonna say, wait, you're from
Chicago.
Sure, gotcha.
You know, like those suburbs.
I don't think I'm Lake Forest.
Okay, of course.
It's right there, North Road. Like downtown. It's really nice. It has a little coffee restaurant. Like Cafe Bob or Levi's. Yeah, they said something. Do that. Maybe I'm getting it. I did love it there. It was wild.
Yeah, it's not a really.
I tried to make it.
Mr. Hogan. What do you want to do on, your case, in the state of Ohio versus Frederick Malone, case number B2203-524?
Yes, thank you, Judge. Good morning. I was in registration judge, where I was had a competency. There was a rather long sentencing ahead of me, but
I understand. You want your client brought down?
I can make his presence, Judge. He,
How do you want to proceed with this? This is a clear trial setting.
I just got some discovery from Ms. Kiefner. However, she indicates to me that there is a bit more to look at, to send me, not look at, to send me. And I'd just like to do another pre-trial in the meantime. We already have a trial date at 11/7.
All right.
So,
Let's continue for a clear trial setting. Ms. Howard, about 3 weeks, since the story is outstanding.
We can do, October 5th.
5th or 6th?
5th.
read my mind.
October 5th?
Read my mind.
Excellent. October 5th, 9 a.m. Wait time?
Yes, I do, Judge. Thank you very much.
Thank you very much. Have a great day.
Thank you, Judge. You too.
All right, this is the matter of State of Ohio versus Terry Curls.
For the record, Your Honor, Michael representing Ms. Crowe.
Thank you. Case number B2202-745. Lisa Trelevin on behalf of State of Ohio. All right, good morning, Ms. Curls. Good morning. This matter is set today for a clear trial setting, but it's my understanding that the parties have reached a resolution on how they're going to, in this case. Is this how your client wants to proceed by way of a plea today?
Yes, it is, Your Honor.
All right. Is that what you want to do, ma'am?
Yes.
All right. Ma'am, are you the Tara Curls named in this indictment?
Yes, ma'am.
Ma'am, how old are you?
45.
How far did you go to school?
I have some college.
All right, so you're able to read and write the English language well.
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Have you ever served in the military?
No.
Ma'am, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Mr. Bolton's signature here and his bar number. Is this your signature right above it?
It is, Madam.
All right. Ma'am, this is an acknowledgement by you that you understand you have a constitutional right to have a trial. We had a trial date set October 24, 2022. But when you sign this form, you're indicating to the court, I understand I have a right to a trial, but I'm giving it up. I'm waiving my right. Is that your understanding of what you were doing when you signed this form?
Yes, Your Honor.
Did you sign this form after consulting with Mr. Bolton about your constitutional right to a trial?
Yes, ma'am.
Do you have any questions about this form?
No.
Do you have any questions about your constitutional right to a trial? I also have in my hand a 3-page document entitled Entry Withdrawing Plea of Not Guilty, Entering a Plea of Guilty. On the 3rd page, there are signatures. And I recognize Ms. T11's signature here, her bar number, Mr. Bolton's signature there, his bar number. But up here, ma'am, where it says signature dependent, is that your signature?
That is, Your Honor.
All right, thank you very much. Ms. T11, would you please put on the record the party's expectation regarding this plea?
Yes, Judge. With the court's permission, we would like to amend count 1 of the indictment to attempt engaging in a pattern of corrupt activity, a felony of 3rd degree violation of ORC 2923.2, and dismiss counts 2 through 5 of the plea.
All right, is that accurate, counsel?
It is, Your Honor.
Is that your understanding, ma'am?
Yes, Your Honor.
All right. Ms. Curls, are you under the influence of any medications, alcohol, or drugs today?
No.
Do you now, or have you ever suffered with or even been diagnosed with any type of mental health difficulties?
No.
Are you presently under any type of community control, supervision, or probation in this or any other state?
No, Your Honor.
Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No.
Has anyone promised you anything at all other than the dismissal of certain counts in the indictment if you plead guilty today?
No, Your Honor.
Are you making this plea of your own free will?
I am.
Ma'am, the prosecutors indicated that it's expected that you will enter a guilty plea to a amended and reduced charge in count 1, attempted engaging in a pattern of corrupt activity, reduced from a felony of the 1st degree to a felony of the 3rd degree. Is that what you talked with Mr. Bolden about today before this hearing?
Yes, Your Honor.
Have you had an opportunity to review this 3-page plea form with your attorney?
We did.
Do you understand what it says?
I did.
Has he answered all of your questions about it?
Yes,
As you stand here now, do you have any questions?
Your Honor. No, Your Honor.
Ma'am, do you believe you've had enough time to fully consult with Mr. Bolden about your entire case before this hearing this morning?
I did.
Has your lawyer answered all of your questions to your satisfaction?
He has.
Have you had an opportunity to review or discuss the evidence that the state has against you with Mr. Bolden?
Yes, we have.
Madam Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence to your knowledge, including any Brady material, if any?
Yes, Judge.
Mr. Bolden, you acknowledge receipt of same?
Yes, Your Honor.
Ms. Curls, are you satisfied with your attorney, Mr. Bolden?
I am.
Ma'am, do you understand the amended and reduced charge against you, attempted engaging in a pattern of corrupt activity, a felony of the 3rd degree?
Yes, Your Honor.
Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in the reduced and amended charge of the indictment?
I do.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes, ma'am.
Now, ma'am, this being a felony of the 3rd degree, do you understand that you are facing up to 36 months in prison and up to a maximum fine of $10,000?
I understand.
Do you understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years?
I understand.
And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand? Are you on post-release control right now?
No.
Well, ma'am, do you understand that if you are convicted of a new felony offense while on post-release control, that in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater. Do you understand that?
Okay, that's clear, my understanding.
All right. Do you have any questions so far?
No.
Since this is a felony of the 3rd degree, do you understand that community control is a possibility? And that I could place you on community control instead of sending you to prison, and I can place you on community control for up to 5 years. You understand?
I understand.
Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court? And if I place you on community control or probation, and you violate the conditions of community control, you'll be brought back before me for a more restrictive sanction, which could include the imposition of prison time up to the 36 months that I previously discussed with you. Do you understand?
Yes, ma'am.
Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service. Do you understand that?
I understand.
Do you have any questions so far?
No, Your Honor.
All right. Ma'am, when you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons?
Yes, ma'am.
Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes.
Do you understand that you have a right to subpoena witnesses to come to court and testify for you?
I understand.
Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
And finally, do you understand that at trial, you cannot be forced to testify against yourself?
I understand.
Do you understand each of these rights as I explained them?
Yes, ma'am.
Do you have any questions whatsoever about your constitutional rights?
No.
Do you have any questions whatsoever about anything we discussed?
No, Your Honor.
Do you understand that if you plead guilty, you are giving up or waiving all of these important constitutional rights?
Yes, ma'am.
Ms. Curls, knowing everything the court has discussed with you today, do you still wish to enter a guilty plea to the amended and reduced charge of attempt engaging in a pattern of corrupt activity, a felony of the 3rd degree?
Yes, Your Honor.
All right. Counsel, is there anything further before I accept the plea?
No, Your Honor.
May I hear statement of facts?
Yes, Judge. Tara Curls from on or about March 1st, 2019 to August 31st, 2021 in Hamilton County, State of Ohio, attempted while employed or associated with an enterprise that can conduct the affairs of the enterprise through a pattern of corrupt activity. Specifically, she was the owner of Windows Planet. She took deposits for Windows from 38 victims that received no Windows in their work. She was she controlled and operated the business, and she was the signature on the bank account where the checks from those victims went into that account. The 30 victims are out $82,812.
All right. And has the state consulted with the victims, and are they in agreement with the plea?
I informed all of them of the plea and no one had any objections.
All right. Thank you. Anything on the facts, counsel?
Nothing on the facts.
Ma'am, did you hear what the prosecutor said you did?
Yes, ma'am.
Is it true?
Yes, ma'am.
What is your plea to count 1 as amended and reduced to an attempted engaging in a pattern of corrupt activity, a felony of the 3rd degree?
Guilty, Your Honor.
Let the record reflect that Ms. Tara Curls was present in court with her attorney, Mr. Michael Bolden, and that Ms. Curls was informed of all of her constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Ms. Curls understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding that it to be voluntary, the court accepts the guilty plea and finds Ms. Tara Curls guilty as to count 1, amended and reduced to attempted engaging in a pattern of corrupt activity, a felony of the 3rd degree, in violation of Revised Code 2923.02. Yes, 02. Counts 2, 3, 4, and 5 are dismissed at the state's request. And I do want to note for the record that on the face of the plea form, there's an agreement regarding restitution of $82,812. Is that accurate, counsel?
It is accurate.
Ms. Curls, is that accurate?
Yes, ma'am.
Is that your agreement?
Yes, ma'am.
All right. All right. Is there any reason why sentence should not be entered today? Asking for a PSI?
We are asking for a PSI. I believe that the prosecution also wants to see if any victims want to make a statement as well.
Yes, just we'd be asking the victim and abstain.
All right, so the court will continue this matter for sentencing to October 17, 2022 at 9 a.m. for sentencing. The court will order a pre-sentence investigation report as well as a victim impact statement. Is there anything else, counsel?
Your Honor, I told my client I would ask, but I was informed that the court would likely not agree to remove the ankle monitor restriction. She's posted the bond in this case, but there are warrants out of Mason, Ohio that are not allowing her to be released because of the ankle monitor. So I'm forward that I would ask the court if Your Honor would reconsider our motion to modify the bond.
All right. Okay. State?
Judge, we'd be opposed, we'd worry that if that's the sentencing date, she would be moved to another county. She may also get a warrant out of Boone County, I'm not sure what's happening in that case.
I see. All right, so I did notice that Ms. Curls posted the bond already. I did not know, I knew there was a holder in place for Mason County. So the issue is the EMU, right? And while I would ordinarily be more than willing to consider removing the EMU aspect, I'm concerned, Ms. Curls, that Mason County or some other county would take you into custody. I would lose jurisdiction over you and we could not proceed to resolve this matter. And so it is in the best interest not only of you, because I know you want to resolve this matter and move on, but also for the victims to have this matter resolved expeditiously. So what I'm going to do is I'm going to deny it at this time, and I will tell you that upon sentencing, I am very much considering removing the EMD component, okay? All right, so we will see you back here for sentencing October 17th at 9 a.m.
Thank you.
All right, thank you.
Anybody else? You guys complete?
Yes, thank you so much.
No problem.
Have a good day.
Thank you. Ms. Howard, I guess, Lauren, do you want to talk to me quickly before this 11 o'clock?
Yes, ma'am.
I haven't looked at it. Let's see. I'm just so excited that things are going smoothly so far. Huh? And that's gonna be on Zoom too, isn't it?
Yes.
So you don't have to shut it all the way down, Warren State.
Would you like me to move it over here? So
Yes,
it's facing-
because it's gonna be on Zoom at 11 o'clock.